Good morning, everyone. My name is Brent Jenneke. I am the Symposium Editor at the North Dakota Law Review, and I wanted to welcome everyone to our law school and to our Energy Law Symposium 2013. As everyone knows, oil and gas, not just law, but oil and gas has been contributing billions to our economy here in North Dakota, and all kinds of issues have come up, including social issues, and of course legal issues. And today we're going to have a day-long symposium with presentations dealing with legal issues that are coming up and have to do with North Dakota residents, companies, and of course lawyers. So with that, I want to welcome everyone, and I hope you enjoy yourselves. Of course, there will be lunch served as well as the breakfast here. Coffee will be here until about noon. After the event today, there's going to be a wonderful reception at the Museum of Art, which is just on the south end of the quad over here by the administration building. And then I would like to thank Crowley Fleck for sponsoring our event today. And tonight the reception will be sponsored by Steptoe Johnson. And of course, I want to thank you all for coming.
Good morning. I'm Jaden Grossman. I'm a member of the North Dakota Law Review. We are pleased to kick off the day with a presentation by Shannon Rogers on mineral states in the context of riparian lands bordering water. Shannon is an associate attorney at Camrud, Maddock, Olson, and Larson here in Grand Forks, North Dakota. She received her Bachelor's of Science in Natural Resource Management with minors in Business Management and Spanish from Colorado State University. She received her Juris Doctorate with honors from the University of Wyoming College of Law. Please join me in giving her a warm welcome.
Thank you all for coming, and I want to thank the North Dakota Law Review for inviting me to speak on this topic today. In preparing this discussion and really this, I guess, lecture on water law and the mineral estate and the interesting cross-sections and issues that are starting to come up in North Dakota, it was a bit of a challenge because there's a lot of detail when you're talking about water law and even more detail when you're trying to discuss the issues involved. My goal today is really not to get lost in the detail and to allow everybody to follow along, whether you have a lot of knowledge in this area or not much. So to start with, I'm going to go through some terminology that is commonly used when we're talking about water law and in mineral law. And the common terms and really the fundamental terms that are dealt with in Brigham Oil are riparian, the bed of the river, accretion, avulsion, and reliction, meander line, navigability, royalty, mineral estates, and surface estates. To begin with, we're talking about riparian lands in Brigham Oil. The one side, the plaintiff's side or the appellant side right now in Brigham Oil are riparian landowners. And the primary characteristic of riparian land is access to navigable or non-navigable bodies of water. Riparian ownership and the rights that go along with it exist upon conveyance by a legal instrument if the property itself abuts upon water and there are no words of exclusion in the deed or the other conveyance instrument. But these riparian rights will be denied if there's any land that claims ownership and sits right along the side of the river or any other body of water. So really it's this concept of land being bounded on one side by either a navigable or a non-navigable body of water that creates this riparian interest. These characteristics apply equally to both the federal, state, and private landowners. And the riparian characteristic is not so much like the other bundles of rights that come along with property ownership in that it can't be transferred freely from the land itself. While the right to use the water may be transferred, the riparian nature of the land itself can't be taken away from the land. The next term is the bed of the river. And the bed, as we probably all imagine it to be, is the land that underlies the surface of the water. The legal definition for understanding what the bed of the river is the land that is covered by water sufficiently long enough to keep it bare of any vegetation and destroy its value for agriculture. In North Dakota and many other states in the United States, the state holds title to all beds underlying navigable bodies of water. And no matter how the river itself shifts, the bed of the river is owned by the state if it's navigable. This is an important riparian boundary characteristic to keep in mind when we're talking about the impact of riparian doctrines on land boundary and property ownership. The next term is the shore zone, and this is really the area of land that's at issue in the Brigham Oil case. And it's the land that lies between the high water mark and the low water mark of the navigable body of water. When we're talking about non-navigability, we're not talking about meander lines, but we're actually talking about the thread of the river that constitute the boundary or the survey boundary for non-navigable bodies of water. In the case of Brigham Oil, we're discussing the Missouri River, which has been adjudicated as navigable. So the meander line is the surveyed boundary, which is to say that the meander line is primarily run to determine the location of the rivers and the lakes. And in the case of land patenting, it's used to establish the quantity of land used for calculating the fee upon transfer. Meander lines were often run inaccurately or fraudulently due to the fact that we didn't have GPS back in the 1800s. And in legal terms, the shoreline of a navigable body of water is actually the legal title boundary for the upland owner. Where the shoreline is located depends on the state and whether it's considered an ordinary high watermark state or a low watermark state. The majority of states follow a high watermark rule. However, in North Dakota, it's traditionally considered a low watermark state. This is the point at which the shoreline is measured. And the significance of using a low water line allows the riparian owner a greater property interest, and where seasonal influences cause significant fluctuation in water elevation, the fluctuation would still be included in the title to the exposed shoreline to the riparian owner. In states recognizing the ordinary high water mark as the measure for the shoreline, any such exposed land between the ordinary high water line and the actual water level at the moment is part of the public domain and could be subject to use and recreation by the public. I've mentioned the term navigability a couple of times already, but determining navigability of a water line can be dependent on both the state and federal definition at different points. Initially, for determining the title to the bed itself, we look to the federal definition of navigability, which requires that a river be navigable in fact at the time of statehood. This navigable in fact standard requires that the water itself be used or susceptible of being used in ordinary condition as highways of commerce over which trade and travel are or may be conducted in the customary modes of trade and travel on water. Wherever, according to federal law, it's determined to be a navigable body of water, title shall have passed to the state at the time of statehood, and it's the state who then takes title to the bed of the river. One of the more recent cases that really goes into depth on the definition of navigability and its application to title to the bed is the case of PPL Montana v. Montana. In that case, the U.S. Supreme Court considered the issue of whether the state was owed rents in arrear from the operation of hydroelectric dams on the upper Missouri River in the Great Falls reach of Montana. In that case, the U.S. Supreme Court determined that it was the federal definition of navigability that controlled in determining whether it was the state title or whether the bed of the river was vested in the state and therefore they were owed rents from the operations of these dams. And one of the most interesting parts, I think, of that case was that the justices considered Lewis and Clark's journals from their travels across the western United States to determine whether or not they would have been considered navigable in fact. I won't ruin the end of that case if most of you haven't read it. It's a pretty interesting case to check out, if not for looking at the journals of Lewis and Clark, if nothing else. So once once a river is determined to be navigable, it's the equal footing doctrine that really allows the state to take title to the bed of the river. And this concept is another concept that is heavily discussed in the Brigham Oil case. The equal footing doctrine vests title in the beds of navigable rivers in the state, and as applied by the United States Supreme Court, the equal footing doctrine prescribes that the shores of navigable waters and the soils under them were not granted by the Constitution to the United States, but were reserved to the states respectively. So the state owns the riverbed and owns the soils and all the minerals lying under them after a body of water is adjudged to be navigable. And additionally, any further disposition by the state by lease, deed, or other conveyance, and any changes in riparian boundaries are also dictated and determined by state law. However, this state control is not absolute and without restriction. The United States Supreme Court applied the public trust doctrine to the state's unfettered right to use or dispose of the bed of the navigable waterways in order to prevent a substantial impairment of the public trust interest in interstate navigation and commerce. And it's these concepts of navigability, commerce, trade, and usage that really control the application of the public trust doctrine. Public trust doctrine was originally intended to ensure that the development of ocean beds did not obstruct navigation. It was later expanded to inland waters on the understanding of navigability and the fact that these riverways and water passages were used to facilitate trade and commerce. The sovereign ownership of the bed gives control to its use and the power to ensure uses do not impair the important public purpose of navigation. Illinois Central Railway Company v. Illinois is probably one of the strongest declarations of the public trust doctrine's breadth. And in that case, focusing on the nature of the grant, the U.S. Supreme Court upheld the state's legislative revocation of a prior legislative grant in fee of about 1 mile of the Chicago harbor. The court determined that this in-fee grant was not within the authority of the legislature because it was an absolute relinquishment of control over the navigable bed, and thus in violation of the public trust restraints. Joseph Sachs, who's probably one of the foremost academics on the public trust doctrine and who also submitted an amicus curiae brief in Brigham, summarized the court's quasi-test for determining whether the public trust doctrine applies to a resource, and additionally whether that doctrine has been violated by the transfer of this interest. Joseph Sachs stated that when a state holds a resource which is available for the free use of the general public, a court will look with considerable skepticism upon any governmental conduct which is calculated either to reallocate that resource to more restricted uses or to subject public uses to the self-interest of private parties. And really breaking down this statement, we're looking first to whether that resource is available for the free use of the general public. It's this communal nature of the resource that's historically referred to as res communis or res publicae, or all other things owned by, because they're unable to be possessed exclusively by an individual. It's this usufructuary right that can be regulated by the state pursuant to their police powers. And for this reason, the state controls the determination of whether the public trust actually applies to a resource, and additionally, whether it would be in violation of the public trust restraints. The underlying purpose of the state's title, as I mentioned before, is to preserve the navigability of the waterways and to preserve public access and usage. In North Dakota, and as well as many other states, this has been expanded slightly under the public trust doctrine, and they've looked more towards recreation now as well as being something that the public has an interest in using these navigable waterways. The interests in the state ownership and control are quite different from traditional property interests of an individual upland owner and should be kept in mind when we're discussing whether it should be applied to things such as minerals or oil and gas development. And in reality, when we're thinking of oil and gas, generally they don't take on this res communis nature. They're lying underground. The public doesn't have free and open usage and access to most of these. Most of us don't have tens of millions of dollars to drill a well to collect the oil underneath. And so there is a slight distinction between allowing the navigability of waterways to be preserved for public use than there would be for allowing the public trust doctrine to expand to mineral and mineral development. Moving on to a couple of mineral estate concepts. This is your $1 million Latin phrase that everybody should get at least once in their legal career. What this maxim of law provides for is that the surface owner controls not only the surface, but also everything to the sky and to the depths. All of the interests making up the surface estate or any estate held in fee can be transferred, benefited, and burdened separately or in part. By conveyance, an owner of an estate held in fee can divide these property rights, but remember the riparian nature of the land itself can really never be divided from it. So the state's argument in Brigham Oil calls on this phrase and this maxim of property law that the bed of the river first extends to the shore zone, and second, that their surface interest and their title interest to that bed would then extend down to the mineral estate itself, and so it's their right to lease out these minerals. The next phrase up there is what the motivation is behind the litigation in Brigham Oil. An oil and gas lease is a contract, and like all other contracts, it needs consideration. Royalty is generally the consideration reflected in an oil and gas lease, and the nature of a royalty allows the lessee to avoid paying the lessor up front for the privilege of exploration and to defer payment of consideration upon an eventual yield accruing from the lessee's production efforts. So why is the shore zone important? The surface area sitting over an oil and gas play is the fundamental factor for calculating a percentage of production and the correlative rights attributed to the mineral estate or the pool of oil underlying the surface. The ownership of the surface acreage is a substantial factor in allocation of the production attributed to the underlying mineral leasehold and equates to a larger royalty payment for the interest holder. So we're talking in dollars and cents here. The more land you own sitting over an oil field, the more royalty payment you get. So now that we have a little bit of a broad background of the concepts that are involved in the Brigham Oil case, I wanted to focus in on the specific law and the case law that's discussed or being argued in Brigham. North Dakota Century Code Statute 470115 was incorporated in the Territorial Code of North Dakota. After statehood, it was adopted by the legislature without amendment. The phrase that the appellants in Brigham Oil are arguing is that the owner of the upland takes to the edge of the lake or stream at the low water mark. This is their stance, that because of that statement in that statute, they take interest, their full interest, down to the low water mark, and therefore have the right and title to the mineral estate. I put 613301 up there because it was asserted by the state for the proposition that they own and have title up to the high water mark. That statute's found in the regulatory provisions of the North Dakota Century Code, and so it provides the North Dakota Board of University and School Lands with the regulatory authority over the waterways of North Dakota. I was really glad to see that when I was reading Brigham Oil and other cases that cite to the case listed below, that I wouldn't have to refer to it by the state engineer's name, because I probably would slaughter that over and over again. But the Mills case is a case from the North Dakota Supreme Court that discussed North Dakota Century Code 470115 in regards to the shore zone interests. That case was an appeal from a partial summary judgment in the state's declaratory judgment action to determine the parties' interests in the shore zone. When we look at the affirmative defenses that were asserted by Mills in that case, one of which included adverse possession, which doesn't apply to the mineral estate or to the right to take oil and gas by adverse possession, And then also looking at the time frame in which this case arose, 1994, which at that time in North Dakota, there was a lot of exploratory drilling, but the Bakken hadn't been discovered for another 2 years at that point. We realized that this case really had nothing to do with the mineral estate and had everything to do with usage of the surface. The primary issue for the court in Mills was the interpretation of 470115, and the court focused on the word takes in that statute and determined that takes was ambiguous in this context. Because of this ambiguity, the court turned to extrinsic aids, such as other North Dakota statutes and case law, and statutes from other low water jurisdictions. The effect of this analysis was the North Dakota Supreme Court's conclusion that 470115 was a rule of interpreting conveyances. A riparian grantee takes under 470115 the interest that is granted to the conveying instrument, or granted in the conveying instrument, to the low water mark, which is the boundary of the grantee's interest. Concluding that 470115 was actually a statute of construction instead of a granting statute was a bit controversial, and a lot of academic commentators, including the state and Brigham Oil, are suggesting that the statute itself may be void because it's in violation of the North Dakota Constitution and specifically in violation of the anti-gift provision in Article 10. The Mills Court does cite to 2 cases, Hare v. Rudolph and Solberg v. State, and I think the state's argument in Brigham Oil is strengthened to some extent by Solberg v. State. That case found that a state statute violated the anti-gift provision because it released a mineral reservation made by an earlier statute. The court stated that the statute was found to transfer to certain designated classes or individuals the property of the state held in trust for all the people thereof as a gift. Thus, the statute in effect in Solberg made a donation to an individual of valuable state-owned mineral interests. Another acknowledgement in Mills was that the state's interest and the riparian landowner's interest in the lands lying between the low and high water mark or the shore zone were coexistent and overlap. The Mills Court found that a grantor of riparian land could never absolutely provide for the interest down to the low water mark because the public trust doctrine and the equal footing doctrines impeded that and created some sort of a servitude over that shore zone. And likewise, the state could never fully abdicate their interest in the bed because of the equal footing and the public trust doctrine. Again, turning to other case law, the North Dakota Supreme Court characterizes this coexistent interest as likened to correlative rights. And when we're talking about correlative rights in terms of water law, we're talking about a common source doctrine, that there's a common source shared by all. Additionally, the correlative rights concept is found in oil and gas law, and it does discuss a common access and right to use a play that lies under multiple tracts of land. However, in those terms, it's used often to combat waste or a negligence accusation. Unfortunately, the Mills Court did not go any further than calling this coexistent interest correlative. And the reason for this was that there wasn't a case or controversy that was actually presented in Mills. There was no use in particular that was being decided. It was simply a declaratory judgment on whose interests are even vested in the shore zone. The court concluded in Mills by saying that the public trust and equal footing doctrines, the state has the interest to the shore zone, which would involve something more than a navigational servitude. And additionally, that under North Dakota 470115, a riparian owner takes more than a mere right of access. So leaving it at that point, it was just a matter of time until there was a case or controversy that the North Dakota Supreme Court could weigh in on these interests in a bit more detail. Now that there's some setup in understanding the background behind the Brigham Oil case, an introduction to the characters and the cases that led up to this, to the oral arguments that happened on September 4th. In Reep v. State, well, the Brigham Oil case is a consolidated case, and the first case was Reep v. State. In that case, the Reeps had acquired their mineral interests over about a 30-year period. Some of those interests were purchased at an estate sale, and at the time of purchase, the state of North Dakota did tax that sale. Additionally, Mr. Reep had recorded his mineral interests and had also leased out these mineral interests for some time. And it wasn't until a lessee actually brought to his attention that the state was auctioning off the same mineral rights that he had held before. So Mr. Reep went to the state and requested that they not auction off these rights and stated that he was the actual owner of them. Well, ultimately, the state did auction off that lease. The Brigham Oil Company filed an interpleader action. They're the drilling company that holds a bunch of these leases that run along the Missouri River. Their purpose was really determining who they needed to pay the royalty to. They named a multitude of plaintiffs and also the state of North Dakota in that interpleader action. The plaintiffs claimed that or challenged the claim of the state to those mineral interests lying in the shore zone. And of the named plaintiffs, it include both private individuals, corporations, local government entities, like the city of Williston and Williams County. Both the state of North Dakota Board of University Lands, or University and School Lands, and the riparian landowners both claimed rights to these minerals, and additionally, both parties held leases out on all of these minerals. The action was removed to federal court because the federal government was involved for some time as being title holders to mineral interests lying along the Missouri River. Ultimately, the federal government was dismissed from the case, and the federal court abstained from deciding the matter and passed it back down to the North Dakota Supreme Court. The federal court identified 3 reasons for abstention in this case. First, the court acknowledged that under the Equal Footing Doctrine and the Public Trust Doctrine, the state of North Dakota originally held absolute title to the lands and minerals underlying the navigable waterways. The court also acknowledged, though, that the state's sovereign authority to allocate these property interests to the riparian landowners, and pointed out that the Public Trust Doctrine would limit the state in some way from completely abdicating its interest in the navigable beds. Finally, the federal court determined that the ownership interest of the mineral estate in and under the shore zone had yet to be determined by the North Dakota Supreme Court, and that this was a novel and important issue of state law, which should first have been resolved by the North Dakota Supreme Court. So this is where it sits today. And until these consolidated cases are finally disposed of, the oil and gas companies along the Missouri River and out in the Bakken have suspended all royalty payments to any party in this suit and have placed those royalties into escrow. What we're talking about is millions of barrels of oil here and tens of millions, if not hundreds of millions of dollars in royalty payments. To further show the incentive, the motivation behind litigating this matter, I wanted to go into a bit more of the statistics on the Bakken play itself, partially because I find it really interesting, and the other part is it helps to put it into realistic terms, I think. The Bakken Shale Formation is over 200,000, or stretches for over 200,000 miles in the Williston Basin, across the border of the United States and Canada and from North Dakota to Montana. It's one of the largest contiguous deposits of oil and gas in the United States, and it consists of 3 different sections: the upper Bakken, the middle, and the lower Bakken. The upper and the lower Bakken have been found to have oil-rich, or be an oil-rich, or have oil-rich source rocks in them. But all 3 have been able to pull and yield oil and natural gas. Williams County and McKenzie County in North Dakota are the most active areas of exploration to date in the Bakken. A 2013 United States Geological Survey assessment found that the Bakken Formation has an estimated mean oil resource of 3.65 billion barrels of oil, and that the Three Forks Formation, or the lower Bakken, has an estimated mean resource of 3.73 billion barrels of oil. This makes the Bakken the second biggest oil discovery in the United States, right behind Alaska, and it's taken the state of North Dakota from number 8 in oil production to number 2 in just under 7 years. There's over 8,000 active wells in the Bakken producing over 700,000 barrels of oil per day, with most of them in North Dakota and Montana. And the ultimate recovery of just one Bakken shale well is approximately between 500,000 to 900,000 barrels. The Three Forks Sanish Formation, which is the lower Bakken region, is another up-and-coming area out in the Bakken, and it's since 2011 been considered its own oil reservoir. In addition to oil, these two formations are estimated to contain a mean of 6.7 trillion cubic feet of undiscovered but technically recoverable natural gas, and additionally 0.53 billion barrels of undiscovered but technically recoverable natural gas liquids. The Brigham Exploration Company drilled one of the best wells in the Three Forks Formation that yielded 5,000 barrels of oil in about a 24-hour period. And to give you a little bit more context for the Brigham Oil case, the state itself, the state of North Dakota, holds 2.5 million mineral acres, and Brigham is an argument over 1% of the state holdings, which is substantial in revenue. So to get on with the appellants' arguments in this case, the appellants, or the riparian landowners, challenged the state's claim to these mineral interests with two arguments. The appellants first assert that the public trust doctrine should be applied narrowly in scope, and they do this by pointing to the Mills Court and their examination of case law from other low-water jurisdictions that found that the public trust doctrine didn't apply to mineral rights or subsurface minerals. They pointed to cases from New York, South Dakota, and Minnesota, which all to some extent held that the riparian landowners' interests do extend down to the low water line. The strongest case for this proposition, and at least for the appellants in this case, is the state of Correr v. State. This is a Minnesota Supreme Court case that held the riparian landowners owned title to the low water mark and could mine ore in the shore zone, so long as they did not interfere with the public trust. Really, the bottom line for the appellants is that while the public trust doctrine is meant to preserve public access and usage for things like navigation, commerce, trade, and recreational purposes, that even though this exists, it keeps intact the proprietary interests of the riparian landowner. And amongst those interests is the right to privately use the shore zone, which would include mining for it. The second argument that the appellants set forth is really a counter-argument to what the state is saying in terms of the anti-gift provision. Their argument here is that there is no specific or specialized class that's been created by this statute. Rather, it's a statute of construction and applies equally to anybody who's transferring land that's riparian in nature. The appellee's argument on the other side is really threefold, the first of which has two subcomponents. And they're arguing contrary to what the appellants say, that the public trust doctrine should be construed broad and that it does apply to the mineral estate itself. The first argument of the appellees starts out with the equal footing doctrine, that the state as sovereign title holders to the bed of the river allows them to collect and recover any minerals or valuable minerals lying under the land itself, and that their title would extend to the high water mark. The second part of this argument is that the nature of the resource itself allows the public trust doctrine to attach to it, and therefore they would have the right by public trust to collect the minerals lying under the shore zone. The second argument, and not really argument, from the state is that they know if the Supreme Court adopts their position and says that, yes, the state is the one who holds the right to collect the minerals, that the Supreme Court's going to look for some alternative meaning to 470115. So their first offering as an alternative to, or as a clarification to the Mills case, is that what 470115 does is allows the grantor of riparian land to give their full interest in the land, which is only the riparian nature of the land itself. So really it's a codification of common law to some extent under this argument from the state. The second alternative that they're providing is that 470115 is something of a strip and gore doctrine. Strip and gore doctrine applies to lands that are abutted by a narrow right-of-way, and under a strip and gore doctrine application, it creates a presumption that the grantor intended to transfer the land, including the right-of-way, rather than to separate off these small strips of land because they forgot that their land actually extended into that right-of-way. I think that this argument, or these alternatives, aren't terrible, especially the strip and gore doctrine application to 470115. The third argument of the appellees focuses in on this anti-gift clause violation. And in that one, they're claiming that this does create a specific class of people and that it would be transferring a substantial amount of valuable assets that are held by the state to a private individual. And for that reason, it's in violation of the anti-gift clause. They tack on an additional constitutional argument under the North Dakota Constitution, and I like to refer to it as almost a parade of horribles. The state says that not only would such a transfer be in violation of the anti-gift clause, but it would also be in violation of the Watercourses Forever clause. And the Watercourses Forever clause provides that all watercourses in the state shall forever remain the property of the state, and the watercourse includes the bed and the banks of rivers up to the high water mark. As interpreted in prior North Dakota Supreme Court cases, the provision does not divest the riparian landowner of his interest in the land, but it does set away out of the control of the riparian landowner the integrity of the watercourse itself. So really the state's saying that we have to own these mineral rights because if we don't, the integrity of the watercourse itself is at issue. And by having right to these minerals, we'll be able to protect and preserve the watercourse and the lands that are running alongside or the shore zone of the Missouri River. I think this is a bit oxymoronic because, as I stated before, both the state and these riparian landowners have leased out these minerals. They're doing the exact same thing with them. So to say that they need to have control and the right to develop these minerals to then preserve this area doesn't quite add up. They'll still have the regulatory authority to dictate whether or not development can occur in the shore zone. I wasn't able to actually attend the oral arguments that happened on September 4th, but fortunately, the Supreme Court provides oral recording or audio recording. And I think it gives you a little bit of insight when you listen to the types of questions that are coming from the bench as to what the justices are struggling with or kind of how they're going to make their decision, I think, ultimately. And there were two real topic areas that they focused on with a lot of their questions. When the appellants took the stand to make argument, the first couple of questions coming from the justices were about the anti-gift clause and how this could not be in violation of the anti-gift clause. And I think the appellants had a pretty good argument here, or a pretty good answer in response to the question of, well, wouldn't this just violate the Constitution altogether to give you, or to turn over these mineral assets to private owners? And their response pointed to accretion statutes and the fact that North Dakota is a low watermark state, and that if we found this statute to be in violation of the anti-gift clause, that then the accretion statute would also be contrary to the anti-gift clause. And now accretion occurs when a river subtly deposits land onto the side of and builds up the banks of the river. And rivers, as we know, shift course, so it exposes bed and it no longer would be considered the bed of the river. That transfers title automatically to the upland owner when we're talking about a navigable body of water. And one of the justices responded to this as, so you're saying the river giveth and the river taketh away, that's not legislature doing it then, so it wouldn't be contrary to the anti-gift clause. And I think that's pretty on point. I mean, if we're looking at a low watermark state, it would absolutely run in line with the doctrine of accretion as applied under state law here, that this statute would allow the mineral estate to be held by the riparian landowner. The second topic that was really covered when the appellant stood up was this aspect of the public trust scope. And I do think that this is the point that the Supreme Court's going to have to decide on how far they want to make this doctrine, or how broad they want this doctrine to go in terms of application to other resource besides water. When the appellees stood up, it was really all about the public trust scope and how they possibly could find that the public trust doctrine would even apply to mineral rights, because no other state has found that the public trust doctrine would go so far as to apply and preserve minerals that lie 2 miles underneath the surface. So when it comes down to it, the Supreme Court's, I think, going to have to look at two things: how they construe 470115 in the past under the Mills decision, and additionally, how they're going to apply the public trust doctrine in terms of whether they want it to expand broader than this concept of navigability and commerce. And although we still use this concept of navigation to determine whether the state holds title to it, and we don't use the rivers anymore for navigation, it doesn't really add up to applying it to such a broad amount of resource that would never really be accessible or usable by the public at large without the public trust scope. A couple of last comments. In my studies in law school and even before, water has always been a big issue. And coming back to North Dakota from Wyoming and Colorado, those fights have been going on for years. And I know they're already starting in North Dakota, but water really is a limiting factor when we talk about mineral development. I think, in my opinion, although there are a substantial amount of wells already operating out west, those numbers could easily be doubled if there was enough water to support that amount of drilling. So I think it's an interesting area that's going to be fought over a lot more coming up if it hasn't already started. And the other comment I would make is that North Dakota is really blessed, I would say, right now in terms of revenue and being able to bring in a lot of exciting new development to the state, and that going forward, there's a lot of planning that can be done to extend the longevity of this type of development. And I'm personally really excited to be in this state and to be a resident of the state to hopefully help in that planning process. So thank you all for coming and hearing me discuss the intersection of water law and mineral estates. And if there's any questions, I'd be happy to try to answer them. You know, I guess the way I come down on it personally, and just the research I've done into the public trust doctrine, and when you think about it in terms of North Dakota being a low watermark state, I guess taking all those into consideration, I think that it almost has to be determined to be for the riparian landowner to develop. I do think that it makes sense. There's a servitude for the public trust to preserve the shore zone and prevent drilling in the shore zone, but I don't think that's necessarily an issue. It's not really feasible to want to drill into the shore zone and then have it flooded every year. It prevents, I guess, consistent production. So I think that it'll probably come out in favor of the riparian landowners. I have no idea. I've been told that the North Dakota Supreme Court tends to take their time with pretty important cases. I mean, this would have a substantial impact for both the state and the private landowners. So they heard oral argument on September 4th. Yeah, I would imagine maybe, hopefully before the end of the year, but maybe not. In terms of the state revenue, it would have a pretty sizable impact. But I think there was something like 30 some odd parties, I think, involved or actually present at the court that day. And listening to the audio, I think it was Chief Justice kept saying, you know, I'm not going to read through all the plaintiffs listed and all their attorneys because we'd be here all day and we'd never have time for oral argument. So I imagine in terms of not only that, but once this decision comes down, there's going to have to be a reaccounting of all the leases and to determine and unwind half of the leaseholds that are there and then reallocate all the royalty interest to the appropriate people. I think there would be, I think that would be the biggest impact, I think, in terms of the decision and how it ends up coming out. I do think that is a consideration, and it falls under the public trust. And really, when we talk about the public trust, we're talking about assets that are held for the benefit of the entire population of the state as a whole. But when we're talking about minerals, and generally the public trust applies directly to the resource. So when we're talking about minerals and royalties, we're talking about revenue that's pulled from the resource. So it's sort of a one-step further extension of the public trust doctrine, and I think that is something that the court's going to have to struggle through, rationalizing that extension, but I do think that's a good argument for why it should be extended and allow for the state to take the royalty interest. Yeah, and actually, there wasn't in the briefs. Because right now, they're just, they kept saying, we're not going to start talking about where we even set the line. We need to figure out who owns it first. Then we'll figure out the boundaries of the high watermark, low watermark issue and figuring out exactly what that means. But that's something that I did discuss in the article that I wrote for the North Dakota Law Review and something that I perceive to be an issue coming up. Because when we talk about oil and gas leases, we're talking about leases that could essentially go into perpetuity so long as production remains on that tract of land. And inevitably, watercourses change course, and you have this variation then in title that will happen down the road. And I think one of the problems is determining who takes on the responsibility of surveying and conducting the resurvey to then reapportion all the royalty payments is going to be an issue down the road. And whether or not you can, by contract, lock in those boundaries and sort of put the risk reward on both parties and say, look, if the river changes course and you may benefit from that, but you also may lose from that too, we're just going to lock it in right now, and this is how it's going to be so long as this lease is in effect. I think those are all considerations that are going to come down the road. Because this is the first time we've ever had navigable riverways run straight through a huge oil play like this. So, I think they'll try, but I think they'll do it. They'll have to do it in scope of what the issue is, and the issue is pretty substantial. I mean, who owns the mineral interest? I think that's probably as narrow as they're going to be able to make it, and that has a pretty substantial impact on the public trust application, at least within this state. And the public trust doctrine is a function of both legislative, so statutory, and jurisprudence. So whether or not it sticks is another question. I mean, legislature can certainly expand upon the definition if they can do that, or if they want to do that. Thank you.